Speaker.
Rahui Katini.
Thank you, Mr Speaker. I'm very pleased to be standing in this third reading debate on the Criminal Procedure Reform and Modernisation Bill, because it is such great timing to be considering the concept of reform and modernisation of the criminal justice system. Just this last weekend, my colleague Dr Peter Sharples gave a groundbreaking speech on this subject. He brought the attention of the nation to the fact that the justice system, including the police, courts and corrections, systematically discriminates against Māori. And although this is an undisputed fact made by authorities no less than the Ombudsman Mel Smith, former Police Commissioner Peter Doon, veteran Māori Legal Authority Moana Jackson, or the head of Rethinking Crime and Punishment, Kim Workman nor Ngāti Kahangungu, I do want to reassert the context from which we would hope any review of the criminal procedures might benefit. And this is the situation by which Māori offenders are more likely to have police contact, to be charged, to lack legal representation, not to be granted bail, to plead guilty, to be convicted, to be sentenced to non-monetary penalties, to be denied release to home detention. For the same crimes, Māori are arrested at 3 times the rate of non-Māori. Māori are 4 to 5 times more likely to be apprehended, prosecuted and convicted than their non-Māori counterparts. And in the case of Māori aged 10 to 13, this is 6 times more likely. And Māori are 7 times more likely to be given a custodial sentence and 11 times more likely to be remanded in custody awaiting trial. It is hardly breaking news, therefore, Mr Speaker, but for most Māori, justice in New Zealand is not positive. It is a system that is unfair, biased and flawed with ongoing and consistent prejudice. What we need, therefore, as indeed the police admitted yesterday, is a focus on crime prevention and innovative approaches to policing. New Zealand needs fresh approaches to reducing the impacts of offending on our communities, and we hope that this bill we can help to reduce the stress upon families who find themselves presented in the justice system. Our review of the criminal justice system will investigate and analyse the facts as the basis for better policy. In the course of our consultations with Minister Powell about this bill, we came to the realisation that should we successfully achieve the amendments we sought, there could be much in this bill which might assist our review. We support the concept of promoting discussions between parties to reduce adjournments and shorter hearings. We endorse also the proposal that guilty pleas be entered as early as possible to help avoid delay. Although I would just bring to this debate an example that was sent into us following our comments about the need for a review of the criminal justice system. We received an email reflecting on the comments of a retiring judge interviewed on Radio New Zealand about 2 or 3 years ago. One of the questions the judge was asked was whether he had any regrets. His reply was yes. He was sad about one thing. He said that Māori coming before him were usually very honest and always admitted to what they had done. Now then, when somebody admits to breaking the law, they're not entitled to a defence. They just turn up to be sentenced. On the other hand, when a person states they're not guilty, they are then entitled to defend themselves, and with a good lawyer, they may well get off. The correspondent put it very simply, and I quote from her email, "But isn't lying fraudulent? So you commit a crime, go to court, swear an oath on the Bible to tell the truth, etc., etc. And when asked, how do you plead, you reply not guilty. So after swearing to tell the truth, you lie and get entitled to a defence. Something is not right here." It is a very interesting question, and unfortunately I'm not convinced that this bill provides us with an answer, other than whatever process is followed, it will be more efficient. That said, I do want to acknowledge the Minister for his commitment to working alongside us in order to achieve our support for this bill. It does most certainly not provide all the answers. Hence our call to conduct a systematic review of ethnic bias in the criminal justice system. But it does provide some immediate responses to improve the system, and for that we are happy to provide our support. We are particularly pleased in the decision to limit the discretion of the court to only proceed to procedural hearings in the absence of the defendant, that is, hearings where determinations of guilt or innocence will not be made. As the Attorney-General himself admitted, this clause was formally inconsistent with the rights affirmed by Section 25E in the New Zealand Bill of Rights Act, that is, that everyone charged with an offence has the right to be present at the trial and to present a defence. We were very pleased with the compromise position of the Minister on the reduction in the threshold for the right of a jury trial from 3 years to 3 months. We fully expect 3 years to 2 years. We fully accept that there will be some people who feel that justice has not been served and may feel vulnerable having a sole judge grant the power of a prison sentence. In the submission made to the Select Committee by David Mathias, he specifically referred to this provision, noting, and I quote, "The right to jury trial is important for reasons based in fundamental community values, and the bill should reflect public views." Accordingly, the Minister agreed to set the jury trial threshold at 2 years and to remove the exceptional circumstances put forward earlier. Another issue of concern for the Māori Party was the clause described as the loss of the right to silence. This was the requirement that the defence disclose before trial issues in dispute. We welcome the decision by the Minister to remove these provisions from the bill. Mr. Speaker, I return to the context in which this bill is located. No one can ignore that there are real issues that need to be addressed when we look at Māori overrepresentation, particularly in our prisons. 90% of prisoners have significant literacy issues, 90% have drug and alcohol issues. The Māori Party review is not an attack on the justice system, it's a search for a better way to achieve justice. We believe that there is a constructive platform that has been established by this new reformed Criminal Procedure Reform and Modernisation Bill, and we're looking for a brave government to go even further and investigate the long-held concerns around ethnic profiling and institutional racism across all levels of the justice system. And I want to finish with one simple statement that every member of the Māori Party immediately could relate to, because it is simply one of those accepted realities of the everyday life of being Māori. Kim Workman, Director of Rethinking Crime and Punishment, has said that this is not a new issue. In fact, he referred to a 2009 study by the Ministry of Justice which showed that Māori overrepresentation had reached an alarming level, not only with police apprehensions, but elsewhere in the system. He shared an example which was along the lines of when the Pākehā passengers of a Māori youth won't let him drive his own car because they kept getting stopped by the police, there is something seriously wrong. Believe it or not, this is an ongoing reality in our lives, in the lives of our children and our mokopuna, and it reflects a criminal justice system in which decisions are made on factors other than evidence of a crime being committed. A truly reformed and modernised criminal procedure bill would look seriously at situations such as these and devise solutions to achieve a system of justice which is fair to all.